It's certainly true. I mean, I've been involved in the law for 50 years now, and if I think back 40 years ago, I don't think I had many 80 and 90-year-old clients. Now I've got quite a lot of 80 and 90-year-old clients. And it is true that many of them slowly lose short-term memory and have other cognitive issues. And what is also a challenge is I've now had quite a few cases over the last 10 years where some family member or other person has questioned the capacity of the person who has passed away at the time they made the will or at the time they signed documents. And in fact, it can be very, very tricky. I've got a case at the moment where the public trustee prepared the last two wills, one year, one the next year, for a man in his 90s. So he went into the public trustee, he spoke to a trust officer, he convinced them that he had capacity. They prepared one will, he came back a year later and changed the will significantly. They prepared that will, they had him sign them, and then he passed away not long after the second will. And one of his relatives came to us and said, look, he's actually was quite ill at that time, didn't have capacity. So we asked the public trustee to check with his doctors, because as the named executor, they could obtain the medical records. And the medical records showed that he didn't have capacity at the time he made either of those wills. And so even though the public trustee had been convinced, they didn't get medical evidence at the time the will was made, and the medical evidence that became available later showed, and the public trustee said, look, in the circumstances, we're not prepared to go to court and get a grant of probate on either of these wills, because we now accept that he didn't have the capacity to make either of them when he made them. And so it's become an increasing practice of mine to say to the client, and some of them are a bit offended, look, would you mind going to your GP and getting a certificate just to say you've got capacity to make your will at the moment? What do you mean? Of course I've got capacity. I know exactly what I'm doing. I'm sure you do, but I don't want in 10 years' time to be dealing with one of your children who's been cut out of your will and who's arguing that you didn't have capacity. So I've had that happen. I've had the case where a child challenged the will. We produced the doctor's certificate that was the same day as the will was signed. That stopped that argument. The same with the enduring power of attorney, the enduring power of guardianship. If you are probably over 60 these days and your lawyer says, look, do you mind getting a certificate from your GP? They're just being careful, because we often have problems. And I've had so many problems now in the last 10 years where somebody's alleged that the person didn't have capacity at the time they signed documents. And I've had some first-hand experience that's been very painful, because it meant that what the person really wanted didn't happen. So it is a big, big issue.